Good evening. It is 6 o'clock. And so we will get started here in just about a minute or so. We'll give some people a chance to get logged on. But if you could take a moment and get signed in, there's a QR code for you to scan there on the screen. We'll start in about 15 seconds. All right. Well, good evening, everyone. My name is Christopher Porter. I am the Director of Training for Century 21 Sheets. I'll be leading this session this evening, along with a co-host or two. But real quick, the purpose of this session is that Century 21 Sheets, ultimately, we want to help you pass your real estate exam. And we'll give you a brief overview of Century 21 Sheets, but we do want to be a resource for new agents. We're going to give you some test taking tips. I do want to give the disclaimer that this is geared towards the Indiana real estate exam. There are state specific questions that are not the same in each state. And the reason I say that is because we do both boost this on Facebook, and occasionally we get somebody from out of state that's joining. So just want to make sure that everyone's aware of the purpose of this session and who it's geared towards. All right. Well, again, here's me. My name is Christopher. I am first and foremost a realtor. I've been in real estate about 3.5 years. I currently am managing our Avon office, but I'm also a director of training for the company. So I do all of our new agent training, which we'll talk about here in just a moment. But I spent 21 years in restaurant management. My contact information is there. Please feel free to reach out to me at any time. This is Andrew Huber. He is our director of new agent growth. I believe he's on a call, so he will hop in here in just a little bit when he is ready. But he will. He's going to be my co-host for this evening. His contact information is there as well. And then Todd Callan may or may not join. I know he had a late meeting, but Todd is a loan officer with Milestone Home Lending. He's been in real estate for about 36 years. He is one of our partners at Century 21 Sheets. And so he often joins so he can talk through some of the lending questions and things that come up there. And last but not least, my other co-host, that's Barley James. He's my puppy. Well, he's not a puppy. He's two something. But he is here. I'm home, so he may bark. I may have to pause for just a second, let him out, that sort of thing. But hopefully that is not the case. Now, this is absolutely more fun if you participate. So I do prefer cameras on. Come off mute to ask questions. No question is a dumb question. It is easier to come off mute than to put things in the chat. I typically have a hard time following the chat. Andrew typically will watch that for me as well. But let's talk through some test taking tips. First of all, if you have completed your exam, I always tell people to get your test date scheduled now. And their main reason for that is so that you have something to work towards. So, just for an example, I mean, they make tax day April 15th, not because they necessarily need everything by April 15th, but it means that people will actually get it done. And if you look at it, a lot of people wait until the week before or on tax day to get their taxes done. So I just throw that out there. Next thing is always trust your gut. Because your gut's always right, or almost always right. And so what I find a lot of times is when people start second guessing themselves is when they start taking answers that they had that were correct and changing them to incorrect answers. There are usually about 5 math questions on your test. If math isn't your thing, do it all first or do it last. I often give the unpopular opinion as well that if it causes you a lot of stress and anxiety, give it your best guess, but don't stress over it, move on, because even if you miss every single question that has math in it, and you get your other questions right, you're going to pass the test. So I always tell people that you will have a total of 4 hours to take the test. Now, not everyone at the testing center is taking the same test, so they may be done sooner because the testing center's PSI, they're doing all sorts of different exams, so in all different career fields. Also know that you can't take anything in with you, but they will provide you a calculator and typically either blank paper and pen or pencil, or sometimes a dry erase board and a marker. So you will have that. Now, one thing that I have seen people do before is the few things that they cram into their brain at the very last second and they don't want to forget. As soon as they get into there, they will write those things on the sheet so that they have them. They do offer a remote proctoring option, and I've not heard great things about it. So a couple of things, they almost never start on time is what I'm being told. But they also don't allow you to move your lips at all. So for some people, reading questions out loud or reading them, kind of to themselves helps them, but you can't do that. So you can also take it in Ohio. They do it on the weekend. So if that's something that schedule-wise works better for you, absolutely. When I took mine, I drove to Terre Haute just because it was 2 weeks out for me to take the exam here in Indy. And I was able to go the very next day in Terre Haute. And then the last 3, be well rested, eat a snack before you go, and don't rush because, again, you have the 4 minutes there, or not 4 minutes, 4 hours to take that test. Let's talk about additional study resources. So there's a website out there, and every program that is out there as far as pre-licensing exams have different study materials. One thing I found very helpful was this website. It's CompuCram.com. It does cost you some money. So the state is, if you're doing state only studying, then it's $49. If you're doing state and national, it's $89. You'll search under real estate broker and then under Indiana. But the nice thing is it's very interactive. They're going to give you a pretest to determine what areas you need to work on. They'll do flash quizzes, flashcards, quizzes, vocabulary words, until they feel like you're good enough. And you also have practice tests. You can take as many practice tests as you want, and the system will tell you when it's ready. And they do also give you a guarantee that if you don't pass, that it's free. And also just a disclaimer, I don't have any affiliation. I don't receive any compensation from CompuCram or Hondros Education Group. I just put it out there as a resource because it helped me. And just last week in my last training class, I had one of the students in there that had been challenged a little bit to pass the test. And he said he went on to CompuCram.com, and that really helped him. And so I've got one other candidate who has been working on it, and he's also found that very helpful. So let's see what is next. It's probably Andrew. Oh wait, here's just a screenshot of what that looks like. So, and they do oftentimes have a discount code on there. So watch the screen for that, because you may have an opportunity to save some money on that as well. All right, so the next question is, what if you don't pass the test? Which you probably will pass the test, but if you don't, not a huge deal. Oops, sorry, didn't mean to do that. Trying to move the people around in here, but you're just going to retake it. Now, if you pass one part of the test, but not the other, you only have to retake the part that you didn't pass. Know that not everyone passes the first time, and your test score does not dictate what kind of agent you'll be. I've got one agent that I think it took her 7 tries to pass the exam, but she's a fantastic agent. So don't let that scare you or throw you off there. But the next question is, what happens after you pass the test? So after you pass the test is when you'll affiliate with a brokerage, and you'll apply for your license with the Indiana Professional Licensing Agency. The cost for your license is $60. Now, currently, according to the Indiana Professional Licensing Agency, they're backlogged on processing applications because they process for all sorts of professional licenses. And they say it could take 4 to 6 weeks to get your license active, and you cannot act as a realtor until your license is active. Now, I am finding that it's anywhere from 1 day to 3 weeks. In my last class, I had one that literally was approved the very next day, and then one it took her about 3 weeks. So, and then from there you'll join my board, the Metropolitan Indianapolis Board of Realtors. Your fees are prorated depending on when you join throughout the year, and it's typically somewhere between $1,200 and $1,600. So just know that those are what your costs are going to be going into it. So I'm going to let Andrew talk here for just a moment because it looks like he has joined us now. So Andrew, if you want to introduce yourself and just talk about, choosing a brokerage. Obviously, you talked to a lot of prospective agents, people that are in pre-licensing courses, and looking at which brokerage should join. But just talk a little bit about that.
Yeah, absolutely. So thankfully, I know Mario and I know Sharon. I'm not sure of the phone number, but yeah, I mean, what I think, I got here late. I'm sorry, I was talking on the phone, but I don't know if Christopher said you guys aren't allowed to talk or you have to be quiet and only he's allowed to speak. Is this some sort of power trip or what? But Mario, Sharon, speak up. All right. This is a partnership. We practice what we preach here. So please make sure, you guys get what you came for. That's the whole purpose of this. I mean, Christopher and I, we have a plan. We're going to read left to right, but please make sure you guys are being proactive and say, hey, hold on a sec. What about this? Or this is confusing. Please, guys, make sure you speak up. And you know what brokerage is best for you? I'm not going to read this stuff down below. It's very simple. It's an agent and a brokerage is a partnership collected toward your goal. Whatever that goal is, if that's making so much money a year, this many closings, right now, the goal is to beat that exam. So what brokerage is best for you? The best brokerage that is in your corner, wanting you to succeed, helping you get to that goal. And that's what we're all about. So of course, after we get past that, what's the next goal? Education. What's the next goal? Marketing, lead generation, let's cross that bridge when we come to it. So thanks to you guys for coming here and getting the most out of your resources, getting to talk to Christopher, getting to talk to me, going through these questions. That's how you're going to be successful in this industry. So keep on keeping on. Thanks for being here.
All righty. Thank you. So if you did not get a chance to, if you could sign in, I will have the QR code again towards the end, or you can go to that web address, which is bit.ly/Cram exam. And that just helps us track who is here, but also I do record all of these sessions. They do change from time to time. I've got some new things in this session that have not been in previous ones. And I actually also live stream it to YouTube. So I put it in the playlist. So today's session will be available pretty shortly this evening after the session is over.
But Christopher, just to make sure you are allowing them to speak, right? They're allowed to talk and have fun,
absolutely,
and have conversation. Okay, just wanted to make sure. I just wasn't sure if I missed that at the beginning.
No, they can absolutely speak, I would hope that they do.
Good, glad to hear.
All right, so just a couple of things that I always like to start talking about, some things that I use to help me study or to remember things. And so the first few slides that we're going to go through are just a few pointers or topics that can sometimes be a challenge or that you need to remember. So fair housing always comes up on the exam. So it's good to know what the federal fair housing law states. So I like to use this acronym here to help me remember what are the federally protected classes under the federal fair housing law. And it's the acronym FRESHCORN, FRSHCRN. And so that's, again, one of those easy things that a lot of people go and they'll just write on that piece of paper as soon as they get into the testing center so they don't forget. And FRESHCORN stands for familial status, race, sex, handicap, color, religion, and national origin. So, and remember this will come up later in some of the questions. So keep that one in mind, or at least I hope it does. We should get to that one. Any questions on that before I move on? All right. So before we move on, I do want to hear from each of you. Just tell me who you are, because I haven't met everyone. So just tell me who you are. If you've already talked to Andrew, you're coming to one of our offices, which office you're going to, and anything else you want us to know. I don't care, favorite color, whatever you want to tell us. So Sharon, let's start with you.
Can you hear me?
Yes.
Yep.
Can you see me?
Yep. Can see you too.
Oh, you can. I've been thinking you can't. all this time. Sorry. My name is Sharon Cardona, and I actually finished the program
Nice.
the end of February, but
Okay.
I went ahead and took the test, and I failed both parts.
Okay.
I'm just a good tester, to be honest.
Yeah.
I get very confused in a lot of the wording, and I don't know if it's maybe my language barrier. I don't know if it's just harder than I thought. But I want to really take it again and hopefully pass this time.
Okay. So I would strongly recommend that CompuCram.com. Like I said, it helped me immensely.
Yes, I wrote it down right now, so I'm
Okay.
like, I'm gonna try it.
Good. And honestly, like I said, some people just don't take tests well. I'm the person that people always hated in school because I was always the first one done with the test, always. But that's just my brain and how it works. So
mine don't work.
Yeah, I was one of those people that hated you, Christopher.
But it is what it is. And again, it doesn't determine what kind of a real estate agent you're going to be. So
Okay.
but great. Well, we're glad to have you. Sam, do you want to tell us a little bit about yourself?
Yeah, so if you hear any noise, I'm in the car on the way home. So it's just exit. So but yeah, so I actually interviewed with you guys. I was 2 Fridays ago. I met with Clay Bowden at the Zions office.
Okay.
Yeah. So that was awesome. So I took my course through Talk to Tucker. I did the online course, like the self-paced one.
Yep, that's what I did.
Yeah, so I was on the audio Zoom, but then I just figured I'd just join in. That way I could still interact with everyone else. But I had heard that you mentioned to get the CompuCram, which is exactly what I purchased after I didn't pass that first attempt.
Okay.
So I took my first attempt last Saturday, and I missed the state by 3 points.
Okay.
And then the national, I didn't do so well. I think I missed like over 10. So obviously, like, national was a lot harder for me. And I think that what got to me was like the doubting myself.
Yeah.
So I had bookmarked a bunch of questions that I was like, okay, well, I just want to make sure that I go back to these and kind of reread them, make sure I didn't miss any words. And I think that I feel like it might have just been better for me just to not go back to them, because some I left, some I didn't.
Yeah.
Some I ended up changing. So I take it again tomorrow. So that's why I wanted to join in. I felt like this would be perfect for me to get some more practice in and be able to get some more insight about you guys and just like studying with other people. I feel like I do well with like other groups of people.
Okay. Well, great. Well, you're going to kill it tomorrow on the exam. So I know that. So good luck on that. And then
Good luck, Sam.
Yeah. And then Mario, do you want to tell us a little bit about yourself?
Hello, can you hear me?
Yes.
Yep.
Okay. I don't know what's wrong with my webcam. It's not working properly.
That's okay.
When I usually use my iPad, but I'm actually taking notes. So
Okay.
on it. So Andrew knows a lot about me so far. But
Mario's good people. He is. He's good people.
Appreciate it. So me, I took a course with the Indiana Real Estate Institute with Brian. Down on, I think it was Post Road. No, not Post Road. I forgot where it was.
I know he's on the
south.
south side. Yeah.
South side, yeah. And so this was in 2019, and I passed it and everything. Like, I felt great. And then 2020 hit. So I kind of took some time for me to like, hey, I'm going to give myself like a whole month just to study, because I get super nervous and I get test anxiety, even though I do really good. But at the same time, when it comes to a big one like that, I second guess myself. So the first time I took the test, I passed the state exam, the portion of it, first try. I did not pass the second exam. Then COVID hit. I took some time off, and I managed to. They extended it for another 6 months, because I guess once you take the course, you have a year
Right.
to actually do it. So they extended for 6 months. So I did it back in 2021. So I kind of took the whole 2020 and I just brain dumped a bunch of things, and I didn't study or anything. I just went in, took it again. And the second time, I failed again.
Okay.
And then that's where I got discouraged and pretty much just quit after that, and I shouldn't have. And then I met Andrew, started talking to him, and then he got me motivated to actually try to do it again. So now I'm actually doing the online course because a lot of it I already know.
Yeah.
And it's just me just going back and just redoing everything, making sure I memorize everything. So hopefully this third time, I'm doing the online course through RECP,
Mhm.
the one that Andrew recommended. So I'm almost done with the first part. I still got 2 more parts. I will be scheduling the test after, like when I get to the third part, because then that's when it motivates me. Okay, I got to get this part done. So I'm hoping to do it by the end of May, early June.
Okay.
But I'm really trying to take my time and actually learn everything, and a lot of
Awesome.
stuff it's like coming back to me. So
Good.
yeah,
Alright.
so that's where I'm at right now.
Well, sounds good. Well, I can't wait to have each of you in my launch training class. So one of the things that I do on top of like this session and manage my office, like I said, I'm director of training for the company, but I do our launch 21 training. So, which is, we do it every month. It's typically, not always, but typically the second and third week of each month, where we'll go through everything, all the things they don't actually teach you in real estate school. So, and the things that you really need. So we'll get to that once you pass the test. But I do look forward to seeing each of you in class. So, and you'll get, like I said, if you like my style today, that's kind of how I am through class, because we spend a lot of time together. I do go off on tangents sometimes, but they're always good. Like there's meaning to them. And sometimes there's good learning that just randomly pops up at different times. So, all right. So let's take a look here at another thing that is good. Oh, come on. Well, there we go. Let's go back to this one. So another thing that I like to remind people on is how many square feet are in an acre, because there's almost always questions where you're going to have to calculate that. So someone who's in our last group, the way he remembered, because that's, for me, that number, I'm like, well, these are the numbers that are in there. I just don't know what order. But the way he said it was 4 old ladies driving 35 in a 60. So that's how I now remember how many square feet are in an acre. And then the other thing to remember is the calculation. So if you're calculating area of a rectangle, it's going to be length times width, or more often you'll see it listed as front feet of that property times the depth of the property. So those are 2 things to keep in mind there. And these will come up on some questions throughout this as we get into some of the sample questions. But I like to give people some study things to just kind of remember. We good on this one? All right.
Yep.
Cool. So the next thing is, when it comes to contracts, things to remember, that the listing contract is between the seller and the brokerage. It is not between the seller and the agent. So, and that comes into play into a couple of different places. Things like, if an agent leaves a brokerage, what happens to that listing? Well, the listing stays with the brokerage because that's who it's with. Now, oftentimes brokerages will release it and let them take it, but they don't have to, because again, that contract is between the seller and the brokerage. The next thing to remember is that a purchase agreement is between the buyer and the seller. So it's not between the brokerages at all. It's between the buyer and the seller. Only things that are written are considered valid. So when questions come up and they talk about things that are oral, or they had discussed this, but there's nothing, but they didn't have anything in writing, then it's probably not valid. Actually, it isn't valid, because all those things have to be in writing. And then the other thing to remember is the contracts can't be terminated just because. All parties would have to agree to a mutual release in writing. And that's part of it, that all contracts have kind of an expiration date or timeline set out in it. And so again, like if it's a listing contract, the seller can't just say, I've changed my mind. If they did just change their mind, then they're going to have to do a mutual release from that contract. And there may be some other terms that go along with that, like a mutual release fee or something like that. But they can't just be like, no, I changed my mind. Any questions on this on contracts? So like I said, there's more that goes to contracts, but these are some of the basics that seem to come through in a lot of the questions. Here's another great one. So minimum down payment for first-time home buyers. So the minimum down payment for a first-time home buyer that's using an FHA loan is 3.5%. The minimum down payment for a VA buyer, so Veterans Affairs, which is for qualified veterans, is 0%. The minimum down payment for somebody using a USDA loan is 0%. And then conventional loans, it is typically 5%, but they can go as low as 3%. You almost never get questions on minimum down payment for conventional loans. It's almost always, if you see a question, it's almost always on FHA, VA, or USDA. So just keep those in mind, because again, those typically things will come up. And good things to note here, a lot of people think that the minimum down payment to purchase a home is 20%, and that's not true. That 20% is if they want to avoid PMI, which is private mortgage insurance, and typically on a conventional, and they have different insurance premiums that go along with FHA, VA, or USDA. So, but yeah, so those are your minimum down payments for first-time home buyers. So keep that in mind, because again, that will come up on your test. And it will come up in some questions that we'll go through this evening. Any questions on this section?
No. Okay.
All right. So I added some slides about title insurance because that comes up quite a bit as well. So these are actually slides I took from Dominion Title, which is our partner title company. We own them, and they do some training for our agents on title insurance. But this is something that does come up. So what is title insurance? And it's a contract to compensate the insured party against claims arising from defects in title, such as unsatisfied mortgages, boundary or easement disputes, liens, so tax liens or mechanics liens, judgments, filing errors, legal access to the property, and unforeseeable title claims, so forgery, fraud, or clerical errors. So with a title insurance policy, they're saying, hey, we're going to insure, up until the day of closing. So anything that they've gone through and they've looked to make sure you have a clean title and all of those things before you get to closing. And if something pops up after the fact, they're going to go back and fix those. So if there's a judgment or something that pops up that they didn't see when they did their title search, they're going to do all of the things needed to get that done. And again, sometimes there are things like, not often anymore with forgery or fraud, but clerical errors, they do happen. Sometimes they forget to record things with the deed or something like that, but they're going to make sure that all those are done if you have a title insurance policy. So why purchase title insurance? And that helps to make sure that the transfer of property is handled correctly. Again, due to that enormous financial undertaking by the buyer, seller, and lender in that whole transaction, but it also really eliminates risks and prevent losses as the buyer is protected against prior liens and or judgment, so they can't come back on them for something that happened before they purchased the property. So that's why you purchase title insurance. Here's a great one. So title vesting, and so title vesting always comes up in the exam as well. Oops. So first of all, these are 4 ways that you can take title. So there's husband and wife, which that would be the couple owns the property as a joint unit. If one party passes away, the title vests to the other property. So again, that's your rights of survivorship. And if there are judgments against one person or another, it can attach to the property. The next one you'll see is a married couple, or sometimes you'll just see tenants by the entireties. And it's the same protections and everything as for a married couple, but they just can't use husband and wife, if it's 2 men or 2 women. So it's a same-sex married couple, and they own it as a joint unit, again, has rights of survivorship. If you're doing tenants by the entireties. Then there's also tenants in common. So tenants in common would be multiple individuals each owning a certain interest. So if one dies, his or her interest in the property goes to his or her heirs. So that's really the key difference there for tenants in common. So, we'll say that, I owned a property as tenants in common with a business partner. And my business partner passed away. The property doesn't automatically just come to me. His portion of the property, whatever percentage that is, and they could be not the same. I could own 75%, he could own 25%, but his portion would pass on to his heirs, and it wouldn't just stick with me. And then the last one is joint tenants with rights of survivorship. And again, it can be multiple individuals, each owning a certain interest. But if one passes away, his or her interest transfers to the other owners. So this is often used sometimes, if you've got, two people that aren't married, maybe they're living together, they live in the house, and they want that if the one dies, that, the property just goes to that other person. So, and there's a really important point here. Never suggest how your client should take title. In that situation, you always want to refer them to an attorney. And that is another important thing to know, that if there's special circumstances that come up or weird things, always either you speak to an attorney, or it may be something that your client needs to speak to an attorney about. Because again, as agents, we can't create forms. We're only filling in things that are on forms that are provided to us that lawyers have written. So, we're not attorneys, so we can't do that. I think we have 2 more title slides. There are 2 or 3 really special title groups when it comes to closing. So one is an LLC, which is a limited liability company. And this is just geared towards, so if an LLC can purchase or sell properties, the main thing is the title company is just going to need their articles of organization, your operation agreement, and any regulations. That way they know who is able to sign documents and things like that. The next one would be a corporation. And again, they're going to need some articles of incorporation, bylaws, resolution from the board of directors, et cetera. And again, who can sign for documents. And then the last would be if a property is in a trust. And so in this case, we're talking about typically a living trust. And so, in a living trust, the people are obviously still alive. So like, for example, my dad and his wife have a trust. And when I sold their condo, the owner of the condo was not my dad and his wife. It was the revocable trust of, my dad and his wife. So the trust owned the property, but things were already spelled out. So in the event that that they both passed, then it's already spelled out who gets what, all the property that the trust owns. And so those things don't need to go to probate. They don't need to go through the court. It's already been determined up front what's happening with those things. And it says who the trustees are and who can sign things, and, who's can sign things even after they die. So any questions on any of these things from title or vesting, any of those? All right. So the title vesting was probably the one area I struggled with the most. So for what it's worth, if you got that down, you're doing much better than I did. I think I still got it wrong on the exam. And then last, I think this is the last title slide, is the types of deeds. So there's the warranty deed, which is the most common in closings. The person granting the deed, the grantor, states that the property hasn't been sold to anyone else, that they're going to defend against the claims of all persons, and they guarantee to the grantee, and the grantee is the person receiving the title, that it's free of any defects that may affect the title, even if it was caused by a previous owner. Now there's also a quit claim deed, which is used to convey any interest that the grantor might possess in the property, The grantor might be a legal owner or not. The deed makes no promises. So anybody can sign a quit claim deed on a piece of property and just saying, hey, any rights I may have to this property, I'm giving to you. But if they don't actually own or have the rights to the property, then they gave you nothing. Now, they are sometimes used for things like in a divorce, where both people are on the deed and they're just quitting their claim to it to the other person, just saying it's all yours now, my interest is gone. And that's why they call it a quit claim deed. And then the last one would be a special warranty deed, and this is most often used in a bank sale and things like that. So the grantor guarantees that they've received title. They're also saying that during the time when they owned it and had title to it, that there were no other liens, judgments, or anything filed against that property. But they don't know of anything that happened before because they weren't, they had just gotten the deed. So those are the three types of deeds that you'll typically see out there. The last one, which they didn't put on here, would also be a personal representative deed. And that's used in the event that the property is in an estate. So the person owning the property has passed. And so the executor or the executrix, which are real words, by the way. Andrew seems to think I make up words, but I don't.
No, hold on. Has anyone heard the term executrix before this evening and not studying?
No.
I haven't.
It's not made up, I promise.
I didn't plan this, Christopher. You brought this on yourself. Okay?
There's other words that he thinks I made up too, but I didn't, I promise. All right, so let's go. Are there any questions before we get into some of the sample questions? And when we do get into the sample questions, apparently I'm going to have to go let my dog out real quick because he's looking at me like, I don't know what he's just being a dog. So any questions before we get into sample questions?
No, Chris, it's just like the title vesting part and then different types of deeds were like the hardest part for me too on the test. So those are the ones where I'm like going extra hard.
Yeah.
That's the section I'm on right now as well. So I'm like taking my time on that.
Yeah, it didn't make sense to me. Like I said, there's another type of way to, for property that we're going to talk about in just a little bit, but we'll get there. Will you stop it? My dog's being Sure. All right. So I'm going to go to the first sample question, and Andrew's going to read it and the possible answers. I'm going to go open the door so my dog can go out, and we'll talk through the question. So Andrew, you're up.
All right. Hurry back, Christopher. I don't want them to count on me to answer this. Amira's seller, Tom, just received the news that his buyers are walking away from the sale. They weren't willing to proceed after they saw the inspection report. Neither Amira nor Tom has requested a copy of the report. What's the most likely reason for that? Amira doesn't trust this particular inspection company. If they see the report, they'll be required to disclose any adverse findings. They are unwilling to pay for the report as the buyer requires. Tom wants to pay for his own inspector so that he can question the inspector.
All right. What are your thoughts?
Let's all shout it out at the same time. 1, 2, 3. B.
B.
Yeah, that is
B
correct.
as in a boy.
Yes. So yeah, if they see the report, they have to disclose any adverse findings. So they're like, nope, we're good. We don't need to see it. All right.
According to the Department of Justice, an agreement between competitors to establish or adhere to uniform price discounts is a type of which antitrust violation? Group boycotting, market allocation, price fixing, tie-in arrangement.
Do we just say it? Oh,
Yeah.
C.
B.
That is
DOJ.
that is correct. It is C, price fixing.
Yeah.
So very good. All right, here we go.
Which of these is not an example of a group boycott? Acme Realty offers discounted services. Behringer Realty and Hawthorne Real Estate Group decide not to show any of Acme's listings and to prohibit showings to Acme buyers so they can drive Acme out of business. Deb, a licensee, is unhappy with the marketing materials a local company produced. She shares her concerns with Irving, a colleague, and they agreed to avoid doing business with this company and to share the news with other colleagues. Sean and the associated brokers in his firm agree to purchase their marketing materials from a single supplier so they get a quantity discount. That just sounds like smart business. D, several brokerages in a certain area agree to stop running advertisements in a local publication. Yeah, C, right?
Yeah, it's good business.
Yeah, that's just like smart thinking.
Yeah. You're
Yeah.
gonna give you know all the answers now, don't you? You're gonna give them all away.
Oh, shoot, I probably do. I was thinking I just became smart and now know this stuff. Bummer. Why couldn't you just let me have that, Christopher? Why couldn't you just let me just enjoy
true.
this?
That's true. All right, here we go.
Now your math, this will stop me in my tracks. Yasmin listed a house at 6% commission rate, and it just sold for $463,500. Her brokerage and the buyer's agent's brokerage split the commission equally between them. Then Yasmin, who has a 60-40 commission split with her broker, Yasmin gets the higher split, took her check to the bank. How much did Yasmin earn from this transaction?
All right.
Well, I don't have a pencil and paper with me, so if
All right.
one of you guys could explain details, that would be awesome.
Yeah, or if somebody wants to talk through how would you figure this out?
Yeah, so I take 463,500, and then 6% of that, 27,810. Then you guys are splitting it equally. So whatever 27,810 is divided by 2 is 13,905, and then it's 60-40. So hold on, let me do some math here. 40, it's gonna be 320. This is where I always get confused. So you'll take, oh, okay. Yeah, so 60% the agent on a 60-40 split. Yeah. And the rest of the brokerage.
Yep. So yes, the answer is $8,343. So I will take that and gladly cash that check. All right. Any other questions on this calculation?
No.
All right. All right. So next one.
Justin decided to build a privacy fence around his yard. He thought the fence was along the property line, but it turns out he built it 1 foot inside his neighbor's property. What will an inspector document as existing on the neighboring property? Easement, eminent domain, encroachment, necessity.
Encroachment.
That is correct. It's an encroachment. Yeah. So the difference between an easement and an encroachment, an easement is giving somebody property to, or I'm sorry, giving somebody permission to access or use part of your property. An encroachment is when you have encroached upon somebody else's property. So you put your shed on their property or something. Now, you could create an easement for that encroachment, but usually they would do it under a different document, a consent to encroach. But yeah, so an easement is permission for somebody to use part of your property. So most common is drainage and utility easement. So like at my house, the along the back, probably 10 feet of my property is a drainage and utility easement. So along there runs not only kind of a ditch for water to drain, but electric lines, cable lines, all of those things go through there. So the utility companies could, if they needed to, say, dig up that transformer and the lines that go to it, they have permission through an easement to go on my property and to do that. An example of an encroachment is my most recent clients purchased a property in like South Broad Ripple in Sobro. And when we did their surveyor location report, which I don't always do for clients, but we did a surveyor location report. it was determined that so there's the house that they live in and the house next door to them. There was a driveway, and at some point they had a shared driveway agreement or an easement, because it was on my client's property, but the neighbors also used it. And basically, there was one driveway that went between the houses, and that kind of split, and they each had their own garage there in the back. Well, when the owner, the neighbor who actually was one who built the house that my clients bought, he had a new driveway put in that driveway, which is on my client's property. But he is the only person that's using that. So he's encroaching on their property. So we just had to have some legal documents drawn up. And really it's called a consent to encroach. Just saying, hey, yes, we know that his driveway is on our property, and it's okay. We're allowing it to do that, because they could have said, nope, we are going to take it. So, but yeah, so there was an encroachment on their property.
Okay. And just clarify, eminent domain is government, and the necessity is that family needs like that roadway to get to their house, basically.
Yeah,
right?
or necessity would be something like maybe you had a large piece of land, and they built another house in the back part of it. Well, the only way to get there is to cross over, the front property, to cross over that to get there. So that's an easement by necessity is typically how they describe that. So yeah, out of necessity, they have to, because you can't have a landlocked parcel.
Yeah.
You have to have access to it. So, yep. Great questions.
Mm-hmm. Which of the following would be a violation of license law? Offering a free home warranty to home buyers and disclosing that to all parties to the transaction. Acting as broker and disclosed principal in a transaction. Acting as agent for both buyer and seller in the same transaction with the expressed oral consent of both. There's that word. Offering part of that listing commission to cooperating brokers. Now, some of that foreshadowing, you mentioned oral consent of both or something in that term, Christopher.
Yeah, we were talking about contracts.
Oh.
Yeah, if I remember my reading correctly, oral is not really, it can be, but I keep forgetting what that word is, where you act as a buyer and a seller. But I think you have to get that in writing.
Is that dual agency?
Dual agency.
Yeah, they either call it, you'll either hear it called dual agency or limited agency.
Limited agency, yeah.
Yeah,
I'm not
the
there
same
yet.
thing.
It's coming back. It's coming back to me.
So in a limited agent transaction or a dual agent transaction, before you can proceed at all in the transaction, both sides need to agree in writing to that dual agency authorization. And it spells out exactly in there what things the agent can and can't do, because again, there are limitations to what the agent can do, because then at that point they have to be faithful really to the transaction as opposed to either side, because again, they're going to know confidential things on both sides, and they can't share that out of fairness. So it has to be express written consent for that. So any questions?
Nope.
All right.
Which of the following would be a violation of license law? To give an opinion of value that a seller relies upon. To complete a sales contract for a purchaser. To act as a limited agent in a real estate transaction. To assure a buyer that a property will go up in value.
D.
Correct.
I'm with them.
Yeah, and you're probably all too young. You don't know who Miss Cleo was. She was a psychic, but she was also a fraud, I believe. But you're not a psychic. You can't tell people that's going to happen in the future, just what things have happened in the past.
Some of us believe in psychics, Christopher.
I actually had my fortune teller cards, something read yesterday. It was actually kind of interesting. But
not going to share what they told you? Did they say was it good or bad? No,
it was good. I can't remember what all it was right now, but one was like, you have some interesting choices Like basically like, and then like my future card was like interesting choices or complicated things, which is absolutely true. So,
Yeah,
it is what it is.
it is what it is.
Now, granted,
Could a light go
now,
ahead?
granted, he had to check his app to see what some of the cards meant. So I'm not sure how accurate my reading was, but
Shoot. Should a licensee wish to purchase property from a private owner, the licensee is required to disclose the licensee's true estimate of market value, must try to market the property prior to making any offer, required to disclose that they are a licensed agent, must tell the seller if the property appears underpriced.
I think
I
I
mean-
remember this question. I thought it was A or C because I know you're supposed to disclose you're an agent, but at the same time, you also have to tell them what their house is worth because of that, or you don't.
nope, you do not.
Oh,
Nope,
okay.
if you're just trying to buy it from them, you don't
Yeah.
have to tell them what you think it's worth. You just have to, by disclosing to them that you're a licensed agent, you're basically
They
saying,
know.
hey, I have market knowledge.
I'm an expert. Yeah.
Yeah, but I mean, if I think it's worth 250,000, I might try and get it for 150 first. And I mean, they can say no, but I don't have to say, oh, I think it's worth 250. Then they're gonna be like, well, then that's what we want for it. But
Okay.
yeah, but
So
you do
this
have
one-
to disclose that.
Okay.
Yeah.
Okay.
Same thing if you're buying a property, there's on our purchase agreement, it asks specifically, the hell did he do? Sorry, my dog just like ran in and like ran into the chair and the table. Come here. What are you doing? He's very excited. He's a lab and they get kind of weird sometimes. But same thing if you're a buyer, you just have to disclose on there that you are a licensed real estate agent. If you're practicing or not, even if your license is in referral, you have
Okay.
to because you have extra knowledge.
Yeah.
Indiana advertising regulations would be violated if a licensee places an advertisement for a listed property under her managing broker's name, but fails to include her own, places an ad for real property services that includes only her name, license number, and phone number, places an advertisement for real property services that fails to disclose the fees associated with those services, does not place a for sale sign on a listed property.
I want to say B, but yeah.
That is correct. Yep, you just have to, it always has to have, it doesn't necessarily have to have that agent's
Managing
name, but
brokers.
it's got to have the managing broker or the brokerage's name. Yep.
So for something like D, now I know, if it's game on, it's got to go into the BLC in 2 business days, but you don't need to have a physical sign in the yard.
Nope.
Interesting. It's just, you should have one, but you just don't
but
need to.
some sellers don't want it, and so you actually have to get permission from them
Okay.
to put a for sale sign in the yard, which and that permission comes in the listing contract.
Yeah, my
Okay.
old
Yeah.
teacher. Yeah, my old teacher said the exact same thing. Like
Yeah.
some sellers like get mad when you do that.
Yeah, or they just maybe they don't want all of their neighbors to know
Yeah.
unless they're like actively looking on Zillow or wherever. Which I learned another fun fact today. Where did the name Zillow come from? They were they put together a zillion pillows, and that's what they came up with Zillow. Some weird fun-
What?
Yeah, a zillion pillows, and that's where they came up with Zillow. Long story. I was at another meeting today with someone, and he's an ad guy, and he used to work for Zillow. Now he works for another company called Ribbon. So anyway,
They need to come up with a cooler story of how they got their name.
I mean, whatever.
Like, what do pillows have to do with houses?
Well, I think it's like because houses have pillows in them, so I don't know. So it's like they just a zillion of them.
Huh.
I don't know. I don't make this stuff up. I just tell what people tell me. All right, next.
When real estate licensee Brian discovered that real estate licensee Arnold was using a choose your neighbor letter to market a property without also listing the property in the BLC, in the local paper, or even putting a for sale sign in the yard, what charge could he bring against Arnold to the National Association of Realtors? A charge of agreeing to discriminate by limiting access to the property, a charge of misrepresenting the property for sale, a charge of not fulfilling his fiduciary duties to his client by not conducting a complete marketing plan, a charge of unfair practice because his mother did not get one of those choose your neighbor letters.
What do you charge now?
Is it The second one?
It is not.
Yeah, this one I gotta read a couple of times.
Yeah, this is tough.
Choose your, so discover the real. Choose your neighbor letter. Listing the property. Would that be C?
No, it's actually A. It's a
A?
charge yeah, it's A charge of agreeing to discriminate by limiting access to the property, which is Article 10 of the Code of Ethics, which prohibits realtors from agreeing to discriminate against people belonging to a protected class. So really the thought here is that by only sending it to certain people, you've now discriminated against other people.
Oh,
By that. So, and and the other thing is because they didn't put it for sale sign, they didn't advertise it in the paper, so nobody else had an option to know that it was for sale except for this select few people. So anytime you get into limiting things, it's probably going to be either a code of ethics violation for the agent or a fair housing violation, or it could be both. So so it is good to know your code of ethics and what things are allowed and not allowed. Obviously I don't expect anybody to know all, I think it's 17 articles, 17 or 19 articles of the code of ethics, but it is important to know to know what things are allowed and not allowed in there.
Okay.
So all right.
When property with a pre-existing lease is sold, the new owner doesn't have to honor the lease unless it's recorded, isn't obligated by the terms of that lease, must give the tenants at least 30 days to vacate, must honor the lease terms unless the lease states otherwise.
D.
D.
That
D.
is correct. It is D. Again, very often I hear like somebody will post on Facebook, oh, help, I need to move quick. My landlord wants to sell the house. Well, if you have a written lease, they can't just be like, nope, you got to go. Or, the new owner can't say, well, I want you have to move in because I want my son to move into this unit or whatever. Can't do it. So whatever that lease states, it has to stay the same. They can't change your rent amount. They can't change deposit. They can't change any of those things, for that. So
Sam and Bridget are cousins who jointly own property. They are both named on the deed. They received title at the same time. They have the right of survivorship, and they each have equal interest and undivided rights of possession. What type of ownership do they have? Tenancy in common, estate and severalty, joint tenancy, tenancy by the entirety.
C.
yay. Yep, it is C, joint tenancy. So now I will say the other one on here, because we didn't talk about estate and severalty. And that really doesn't have to do with, well, it does have to do with title, but typically you're going to take title fee simple, which means you're going to get all of the rights that go with that property. But in estate and severalty, they have severed some of the rights of that property. So that could be they have severed the mineral rights, or they have severed the air rights. And so when we talk about estate and severalty, a couple of examples, you have a farmer that has, owns a piece of land, but they have sold the mineral rights to an oil company. So especially you'll see this out west in like Texas. So you have cattle out grazing in the fields, but then you have oil derricks that are pumping the oil. So that farmer doesn't own the mineral rights. So he owns it in severalty. Another example is New York City, Grand Central Station. The city of New York owns the land that the Grand Central Station sits on. However, they have sold the air right, so to the part above it, to, I think it's Hyatt is who owns that hotel. So Hyatt owns the hotel. So they own the air above it, but they don't own the actual land that they're on. So those are a couple places where estate and severalty comes into play. The key there is to remember that it's severed.
What would play a role with like mobile homes where you don't own the land? Is that just you're leasing the land?
Yeah, it's just a lease. Yeah, it's just a lease if you don't own it. So yep, that's where your lot lease or lot something comes into play, lot rent.
Okay.
Marcus,
listen.
I don't like that question.
You got me all fired up. What type of loan is neither guaranteed nor insured by government agencies? Conventional, an FHA, a USDA, or a VA?
A.
That is correct. So
It's the one that doesn't sound government-y.
yeah. Now, the thing to know that there are still the government-sponsored entities which not back, but write the rules for conventional loans. That'd be Fannie Mae and Freddie Mac, but they are not guaranteed nor insured by the government.
A buyer is purchasing a property for $500,000. He has a down payment of $50,000 and is financing the rest. What's the amount of the loan origination fee if the lender charges 1.5 points?
How would you figure this one out?
It's 1.5%.
Okay. Of what?
Or
Oh, man.
Well, let me ask you this. What is a point?
So it's, I think it's credit for you, for the mortgage.
Right. And then points are used in a couple of different ways. A lot of times it's discount points because they're buying down an interest
Discount
rate.
points, yeah.
Yeah. So a lot of times you see it listed as discount points, but what is, so it's a point is 1%, but 1% of what?
Yeah. It's been a while.
Is it
So, I mean-
is it the total purchase price or is it the amount that's being financed?
No, I think it's a total purchase price because
Okay.
that's the loan that you're getting, right?
Well, no, you're actually going to get the
I
loan.
thought it
on
was
an-
the other way.
It is.
other
So
ways.
yeah.
Okay.
So it's 1% of the amount being financed. So
Okay,
in this scenario, we know that the total amount's 500,000, but they're financing 450,000 because they have a down payment of 50,000.
okay,
And so 1.5 points is 1.5% of the financed amount, so that'd be 450 times 0.015. So you get $6,750. So any questions on that?
And then
I-
like another thing with discount points is you can also like buyers use those to bring down, is it their interest rate?
Correct.
Okay.
Yeah, and that's typically what you see them being used for, is buying down interest rate. So you don't typically see it as your loan origination fee, because that's really hefty for a loan origination fee. I mean, for like Milestone Home Lending, their loan origination fees, I think it's $1,095. So if they were doing points on that, it would be pretty pricey.
so just to clarify, it is going to be the finance portion,
Correct.
right? Okay,
Yep, it is. A 1 point is 1% of the financed amount.
okay.
I don't like that one, so we're not doing it. All right, here we go.
Allison and Brent are financing their house purchase of $232,500 with an FHA loan. Their credit score qualifies them for the minimum down payment. What do they need to put down?
All right, so what's the minimum down payment for an FHA loan?
3.5%?
Correct.
Nice work.
So when you do the math, 3.5% of 232,500 is $8,137.50.
Regina purchases a farm with 80 acres and owns her property in severalty. What does this mean for the company that purchased the mineral rights from the previous owner? Regina and the company that purchased the mineral rights are automatically tenants in common since they share ownership of the property. Regina didn't purchase the mineral rights, which had been severed from the property by the previous owner. Regina included the mineral rights in her purchase agreement since she could not otherwise own the property in severalty. Regina is the sole owner, and the company must accept a fractional portion of the sales price in return for forfeiting the mineral rights.
B.
Yep, that's correct. It's B.
So could you explain like with A and B, I feel like if I was to read those, I
Mhm.
could kind of see like why it's either or, because like A says that they kind of like share, but well, I guess it wouldn't really be that one because they don't technically share ownership. Is that
Right.
how you would kind of?
Yeah, so they don't own ownership of everything together. So it's not like the company that bought the mineral rights can say, "Hey, I want to use 40 acres to do something else on." They didn't buy those rights. They only bought the mineral rights. And so that's what, when you talk about in severalty, that they've only bought specific rights and
Mhm.
not the whole plot of land.
Got it.
So
What's the most common occurrence of severalty or anything like that in central Indiana? What's the most common thing that this would apply to?
That's a good question, because we don't really have, I mean, we do have some mining and things that goes on that, you know, like in some areas. So you could have some of that, but even then, yeah, I mean, you could, because you could have a mine where the mine shaft is, you know, further away, and they dig down and they go underneath and do
Yeah.
that. So that could be, you know, we don't do a whole lot of mining in Indiana anymore. I'm sure there are some places where they have sold the air rights for some things. I don't know exactly, like the wind farms, like how they do that. That
Oh,
I think
yeah.
I think they're just more leasing, you know, the little plot of land that that's going on. I don't think they're actually like buying those rights. So I don't know that we necessarily have much of that going on here. Like I said, the biggest use I see is in big cities where places are selling air rights so they can build above certain things, and then like farms where they've sold mineral rights. So when you're looking at you know, oil, you know, drilling for oil, you know, in other places it might be gold or diamonds or whatever.
Yeah.
But yeah, that would be I don't think that I know of any, which is why we don't really do much with severalty in Indiana. I've never had to do anything with that here in all the transactions I've done. So,
Cool.
all right, next one.
Real estate licensee William is preparing for a sale agreement that will include an unusual circumstance. What's his best course of action? Consult an attorney, create his own forms. That can't be good. Use an existing form and write an addendum that covers the unusual circumstance. Use existing forms but modify the language to address the unusual circumstance.
Is it so? I've had trouble with this one before. I would normally pick D, but I feel like, is it A?
It is A. So your first course of action, if there's some unusual circumstance, is to consult an attorney. Now the attorney might say, yes, you're going to use this form and this is how you're going to, you know, change some of the language or maybe write into further conditions. But absolutely your first course of action would be to consult an attorney.
Could this be one of those things that when you're in the field, they could just bring that up with their manager and consult the legal hotline?
Sure. So, you know,
Okay.
depending on what it is, I mean, your first step most of the time is going to be to check with your manager. And sometimes we'll say, oh yeah, no, this is how you're going to do this, and you move on. But from there, and I had this situation just last week, I think it was, where I had an agent that had something that came up in a transaction that was kind of weird on how we were going to do something on a form. And so she called me and I was like, I don't know. So I escalated that to Tracy Hutton, who is our managing broker of record. And, you know, we kind of talked through some things and we went back and forth on a couple of things. And she's like, you know what? I don't know. She's like, we need to get more advice. So she contacted the Lisa Legal Hotline, which is the Indiana Association of Realtors legal hotline. And so she contacted them. We even stumped them on this one. So they then consulted, you know, with their own attorney, et cetera, and then got back to Tracy. Tracy got back to me. I got back to the agent.
No, they actually called me. I had to help them, Christopher.
They called you? No, they
Mhm.
didn't. No, they didn't. You're not an attorney. We don't need to do that one.
Yeah, I read that and I'm like, that sounds really expensive to have to consult an attorney. But guys, you can outsource that to your manager at C21.
Yeah, we have options. And we also have our own attorney. So if it's something, you know, that we need to go in-house on, we have our own legal representation too.
Regarding sub-agency in the state of Indiana, a brokerage firm must disclose this to the MLS/BLC, may offer it only if the buyer and seller agree in writing, may offer it only if the fees charged to all parties are equal, may not offer it under any circumstances.
D.
Correct. Yep. Sub-agency is not allowed in Indiana.
Which of the following needs to be licensed to sell real estate? county assessor, the executrix of an estate paid a fee. I don't even want to read it. It's just frustrating. Just eliminate it. A neighbor helping sell a property in exchange for use of a timeshare in Florida, or an auctioneer.
Is it C?
Correct. It is C. And why is it C?
Because no unlicensed person can receive like any sort of fee, right?
Right. Yeah. Or anything of value. So
Yeah.
yeah, exactly. Very good.
A broker associate may do which of the following? Maintain their own escrows, trust account, advertise in their own name without the name of the firm, maintain a separate office and signage at their home, only operate under the oversight of their managing broker.
Only operate under the oversight.
Very good. That is correct.
A licensee can lose his or her license for which of the following? Allowing funds to be deposited into an interest-bearing escrow account, paying a commission to an unlicensed person, acting as a disclosed limited agent in a real estate transaction, charging a commission rate higher than the real estate commission allows.
B.
B.
Yep.
B.
Yeah, you can't pay a commission to an unlicensed person, which is also like you can't post, hey, to your family and friends, hey, if you send someone to me and they buy a house or sell their house through me, I'll give you $100, $500, whatever it is. You can't do that because that's paying a commission unless they're licensed. Now, if they are licensed, that's different. But if they're not licensed, you can't do it. It's one of my favorite
If a property
questions.
is oh, this is a good one. If a property is deemed to be psychologically affected, the listing agent must disclose this fact in the nature of the affectation to all parties, must disclose this fact to prospective buyers, may not intentionally misrepresent a fact in response to a direct question, has no obligation one way or another because psychological affectations are not considered to be physical defects.
C.
That's correct. Yeah. So, so there are three things that are considered for a property to be considered psychologically affected. Who can name one of them?
So crime.
Yeah. So
One
a
of them?
major, yeah. So a major crime does not have to involve death, but it could be, hostage situation, drug dealing, things like that, but major, like not just, somebody stole the kid's bike, right? It's got to be a major crime on that. What's another one?
If it was used for like manufacturing like those hard substances, I think.
That wouldn't fall under psychologically affected. Now it would be, considered a clandestine meth lab,
Yeah.
which strangely enough, I had to have that conversation with one of my clients. I'm like, are they this is actually a true conversation we had yesterday. I'm like, do you think they're making meth in that house? Because she did find either a crack or a meth pipe in the house when she was taking photos. But we talked through it and we don't think that they're actively making meth in the home. But yeah, so that doesn't fall into that. But what else? There's two others.
Ghosts. Is that one or no?
Are ghosts real?
I don't know.
No, it is not.
Hold
ghosts.
on. You just said you had your fortune read to you yesterday, but you take a hard line against ghosts.
Yeah, see, exactly.
You know what?
So it's like what I remember seeing like a question similar to this when I was like studying. Now, like HIV, that's one that you can't disclose, right?
No,
you
if you can. So if you know that somebody in the house was living with HIV, that is a psychological, that would make a property psychologically affected. Now, my question is always, how would you know unless they openly disclosed it to you?
Yeah.
But so you may not know that. And so again, when it comes to psychologically affected, it's if you have knowledge of something. And then there's one more. So we've talked about major crime. We've talked about somebody living in the house with HIV, and there's one more.
Oh.
A death.
It's where ghosts come from.
Death.
Yeah. So if somebody died in the home.
Okay.
Yeah. So like, for example, my neighbor did pass away in his house. And so if somebody asked me the direct question, if I was selling his house, did someone die in the house? And I know that they did, I would have to put that there. But So but the answer is C, that you may not intentionally misrepresent a fact in response to a direct question. Now, you're not going to put in your property description, well, this was the scene of the 1999 quadruple murder, blah, 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 blah. You're not going to put that in there. But if somebody asks you, hey, is this where this happened? And you know for a fact that it did, then you would have to answer appropriately to that. So, yes. All right.
When acting as a limited agent, a licensee has certain limitations as to how they should conduct themselves. Which of the following would be a violation of those limitations? Giving the buyers information about other homes that have sold in the area, refusing to tell the buyer why the seller is selling, failing to tell the seller that the buyer would probably pay more than they had offered, telling the buyer that, in your opinion, the property is overpriced and the seller would probably take less.
D.
Correct. D. Yeah, you can't tell them those things. You can, because again, you're going to know things from either side. You may know what price the seller is going to take, but you can't share that if you're doing a limited agent transaction. So, all right, next.
In the state of Indiana, net listings are not legal. Require the written consent of all parties, must state the maximum fee, must not allow the broker to net more than the seller.
C.
Nope.
B.
Nope. Two more choices. The correct answer is A. No, the correct answer is A. Net listings are not legal in Indiana. So a net listing, a net listing would be one where the seller said, hey, as long as I get this amount of money for my home, anything above that is your commission. And so the reason that the state of Indiana says, hey, net listings aren't legal is because an agent could be unscrupulous and take advantage of a client and say, oh yeah, I think your house is worth 150 when they know it's really going to sell for about 250. So now they sell it for 150, or they sell it for 250. Now they're making $100,000 commission, and that's not fair. So they can take advantage of that consumer. So,
I didn't know it wasn't legal here.
Nope, it is not legal in Indiana. I think there are some states where it may be legal, but it is not legal in Indiana. So, all right, next one. And it looks like we have somebody who did join. So JF, I see you on there. We will here shortly have a place for you to sign in. Now this session has been recorded and is actually being live streamed right now on YouTube. So if you sign in when the link pops up for you to do your sign in, we will, you'll get a link to the playlist that has not only this session, but some previous sessions that we've done, because we want to make sure that you get all of that information. So, and for anyone else who didn't sign in, when you do, we'll get to that here before we end the call. Like I said, you'll get that. And this one will actually show up fairly quickly because of the way that I'm streaming it to YouTube. So just thought I would share that information for you. Ooh,
a seller received $800,000 for a 5.5 acre rectangular parcel alongside a road frontage. The property is 400 feet deep. What was the price per front foot of the property? $2,363.64, $598.95, $1,335.67.
All right. So how would you figure this one out?
Square feet. Will you convert the acres to feet?
Mm-hmm.
And then 400. Okay, I gotta do some math.
All right.
So once you do that, it would bring you to 239,580.
Okay. And then what? So we know how many square feet we have. Now what?
So then would you divide that by 400?
Okay. And what will that tell you? That's going to give you 598.95. But what is it? Is that the final answer, or or do you need to do something else now?
Wait, did I say multiply by 400 or divide?
No, you said divide. You said divide the 2 whatever it was by 400.
Okay, well, I multiply. That's why I got a big number. When you said that, I was
Okay.
like, wait.
Yeah. But that's so 598.95 is going to be what? So if we know it's 400 feet deep and we've divided that out of the how many total square feet it is, what is that telling us?
Do you still have to divide the 800 by the number that you just got?
Yeah. So here's on the screen, it now shows, so we had 5.5 acres. We multiplied it out and got that 200 and whatever thousand square feet, divided it by 400. And that told us how many front feet there are. So we know we have 598.95 front feet. But the question is how many dollars per front foot? So now we need to divide the 800,000 by 598.95. And now if you look at it, I mean, the answers that they gave you a couple of them. So like if you take your 800,000 and divide it by 400, you're going to get 2,000. If you take the, when you get that, you get 598.95, but that's actually how many feet are in the front. So the actual answer is $1,335.67 per front foot. So yeah, so that's where they get you when the answers, because again, you do some math and you're like, oh, well, that's one of the answers. And so you just choose it. And it wasn't all the way to where you wanted to be. So there's the calculation on that.
I think Mario's hoping that the test is just all math, all just long math problems.
And you know, it's funny. I was really good at math and back in high school and some in college. Like I took math classes and I was really good. It's just the word problems and conversions is what always gets me.
Yeah. And that's why I say, so on those, when you get those word problems, draw it out. And that's why I drew this one out and did that, because again, that's how my mind works. It's like, well, hold on, I need to kind of figure this out. So I'm going to go to the next question. Then I'm going to go find my dog because he's out barking at something, probably a squirrel, because the squirrel likes to sit in a tree and laugh at him. So I'll be right back.
If individuals want to use their property in a way that's not permitted by a zoning ordinance, they must submit a request for a variance or special use permit to which of the following groups: the Architectural Review Board, the Building Department, the Planning Board, the Zoning Board of Appeals.
I want to say D.
So
B?
if you guys know the answer to this, give me an example. What's an example? Like you want to build like a fence in your backyard.
Would
So
it be
what
the
would you have
B?
to do? What'd you say, Sharon?
B?
The building. I don't know. All right, here we go. Yes, that's correct. Oh, hi, Christopher. I was just about to answer Sharon, but you sat down. So go ahead and answer for me.
You already know the answer, don't you?
I did. Yeah, I know. Go ahead and share with everybody. I was just about to say it.
D.
See, Sharon, I told you it was D. The zoning board. And then I just realized this is recorded, so I guess
I'm gonna find out
caught soon.
Yeah.
No, I've never seen this question before, Christopher. I genuinely didn't know the answer. What would be a good example of this?
Zoning Board of Appeals.
Well, like you want to build a fence in your backyard and it's not permitted, or
no. A good example would be that you bought a piece of land and it's zoned agricultural, but you want to build a house on it. So now you have to get it rezoned to residential. So you have to go to the Board of Zoning Appeals, and it could be, and sometimes they allow certain things, like it might be in a residential area, but they might allow you to operate a dog kennel in that residential area, but you have to get a variance or a special use permit from the Board of Zoning Appeals to do that. Not that one. I want to get to a couple questions because we're almost out of time. Here we go.
Tom and Roseanne are interested in a property, but before making an offer, they want to make sure there aren't any registered sex offenders living in the neighborhood. Which of the statement is most accurate? It's up to the buyer to perform due diligence and research whether sex offenders live in the area. Licensees can direct clients to the state's registry. Sex offender information is not public, and a seller is not required to disclose it. The licensee must research the neighborhood to determine if there are any registered sex offenders. The sellers must disclose the location of any nearby sex offenders. I was not prepared to say sex offenders so much today, but here we are.
I want to say it's either A or B, but I think it's A.
Yeah, I think it's A.
Yeah. So, and again, this is again how they try to trick you sometimes, because they said which statement is most accurate. A and B are both accurate.
Yeah.
So we do, in fact, direct them to the state's registry in our purchase agreement. However, ultimately, it is up to the buyer to perform due diligence and research whether sex offenders live in the area. And that's the same thing for agents. When somebody says, "Oh, is this a safe area?" I can't tell you what a safe area is or isn't. That's up to you to determine if this area meets, your needs and, wants and needs. So, yeah. What were you saying, Andrew?
I was going to say, can't we kind of build that idea to just talking about crime in general? And
yeah.
You really do have to be careful with that stuff.
Yeah. And some of that also gets into things like fair housing. But again, when we look at, in this one, or when it comes to crime, because somebody says, "Oh, is this a safe area?" And you're like, "Oh yeah, it's super safe." And, the day they move in, somebody steals their stuff or whatever, or there's a shooting, like you can't be held responsible for that. So that's why ultimately it's up to those buyers. And I always use the example of, my best friend's mom was buying a house. I was her agent. And, she bought a nice home in maybe slightly undesirable area. And he was like, "Why did you let my mom buy a house there?" Because literally the week after she moved in, there was a murder on her block. And I was like, listen, I can't determine for her what is a good area for her. I was like, that's where she wanted to live, so that's where she's living. And that was how it went. So, yeah, this one.
Tabitha listed her property for sale, but it's been on the market for several months with no offers. She decides to terminate her listing agreement and rent the property out instead of selling it. Assuming that her listing agent has fulfilled all of his responsibilities under the contract, can Tabitha terminate the contract before its expiration date? Only if she and the listing agent mutually agree to terminate the agreement. Only if she succeeds in converting it to a rental. Yes, because she's received no offers on the listing. Yes, she is entitled to terminate at any time.
A.
Correct. It is A. Only if she and the listing agent mutually agree to terminate the agreement. So, all right. Oh, last one. And then, yeah, this will be our last question.
Corinne is 68 years old and employed full-time. She's of Spanish descent, is raising her 12-year-old grandson, lives with her partner, Catherine. She requires an accessible apartment because she uses a wheelchair. Under which of the following federally protected classes might Corinne be protected if she faces housing discrimination? Age, employment status, national origin, familial status, and sexual identity. Age, race, familial status, sexual identity, and disability. National origin, sex, disability, and familial status. Religion, familial status, and disability.
Would be B.
I've heard B and D. So let me ask you this. So if we're looking at D, what religion is she?
Oh, good one.
We don't know. I mean, they didn't.
Yeah, we don't know.
I mean, it's one of those we could assume, but we don't know. Because again, there's typically in some countries you have particular religions that are more dominant, but again, you don't know.
Yeah,
So since we don't know, it can't be D. What about B was the other one that somebody had brought up. What
60, she's
68.
Okay, is age a federally protected class?
No.
So remember one of the very first slides we talked
So
about
it's
fresh corn.
T.
Race, sex, color, religion, national.
Yeah, so fresh corn. So it's familial status, race, sex. I've got to think of what those letters stand for.
So is it D? I mean C.
It is C. So national origin, sex, disability, and familial status. So federal fair housing laws don't name age, employment status, or sexual identity as protected classes. So Corinne would be protected if she experienced housing discrimination based on her national origin, sex, disability, or familial status. So now, then that's why I wanted to make sure everyone understood what the federal fair housing law has in it, because the National Association of Realtors has also included gender identity and sexual orientation as protected classes as far as in the things that we as realtors must abide by, but it is not part of the federal fair housing law. So,
But
all
here
right.
in Indiana, we have to abide by that.
Yeah, so Indiana actually has some other protections. So statewide, we do not have protections based on, oh shoot, now I got to make sure I'm saying the right thing because I teach this. I don't believe that sexual orientation and gender identity are not included in the state. However, certain counties do have that. So in Marion County, we do have protections based on that, and also military and veteran status. So,
Okay.
But federal fair housing law does not count those. So, all right. So we are at the end of our time. So if you didn't get signed in, please do. Again, the session's being recorded. It will be available on YouTube here shortly. You're going to get a link when you sign, or when you do your sign, you're going to get a link to the playlist that has past sessions as well. So if you notice, we did skip some questions, but I don't necessarily skip them in every session. It just, time wise, and I do mix them up from time to time as well. So there are other sessions for you to look on there. So please sign in. But does anybody have any comments, questions, or anything before we finish out the evening?
Can I ask a question about just like a quick question about a topic we didn't cover?
Absolutely.
So one of the things that I had seen on my exam was mill rates. That, I don't know why, it's just like, it's confusing, like especially the math problems.
Okay.
So, because don't you have to, they give you like a mill rate of like some decimal point or whatever. Because you have to divide it by like 1,000, right? Is that what it is? I don't know. Just mill rate in general is just like confusing when it comes to math calculations.
Yeah, it's confusing me too, because I don't know what you mean by, you said mill rates?
Yeah, or like mills.
I
know what she's talking about.
Okay,
Yes.
help enlighten us.
Well, I mean, I know what she means, but it's converting the mills. They give you a sheet. They give you a sheet before you take the test that has like a diagram. Hold on, let me find it.
It's not the how do you say amortization table?
Amortization.
No.
Yeah,
it's not that
amortization. No. I'll tell you what, I will find some information on that and I'll email it out to you.
Okay, perfect.
I'll be honest, I don't know about that one. I was like, please don't ask me something I don't know. Because you got to remember, I did take the test like 3.5 years ago, but I haven't had to take it since then.
Yeah.
I did have a question.
Yes.
That program that you said,
yes.
The 89, what was it again? What was the name? Sorry, I thought I wrote it down, but I can't.
It's CompuCram.com. I'm going to put it in the chat as well.
Okay. Cram.
Yeah, CompuCram.com.
CompuCram.com. Okay, perfect.
Yeah, absolutely. Any other questions?
I figured out what she was talking about. It's about the tax payable per dollar of the assessed value of a property.
Yes. Yeah, that.
Wow.
So, yeah, I'm confused about that too. I just know what it is.
Okay. Well, let me do this.
I don't know how to explain it. Yeah.
Yeah. So let me do this. Let me find a good answer, and I will not only email you that, but also a video explaining it.
Awesome.
So I'll get that. It'll be sometime tomorrow. But yeah, I will get more information on that because it's not something I'm real familiar with. You're like, I thought he was supposed to know everything. I don't, I promise.
You're good.
Right. Great. Well, thank you so much, everyone. And thank you, Andrew, for joining us. Always a pleasure to,
Hey,
yeah.
I'm so sorry, Chris. I know we're running out of time.
Yeah.
Can you just please explain Percheva or Percheva or something like that? It's like a French word. It has to do with what's it called? Oh my God. Life estates and stuff. I always get confused on that word and what it like associates with.
How do you
Is
spell
it the pure to V word?
Yeah, per de vie. Yeah, that one.
Isn't that like life of another or something like that?
But it is, but then I always get confused because it also says, I thought that was for the other definition of a life estate.
Oh, yes, for pure ultra V.
Yeah, that.
Yeah, pure ultra V, and it's a life estate. Hold on.
Every time I try to look up the word, I get confused more and more because it shows me one thing, and I
Different.
think it's different definitions of that word.
Yeah. So that is like an example, Bob is given use of the family house for as long as his mother lives. So he has possession of the house pure ultra V, which is as long as another person lives, because ultra means other, and V is life for another person's life. So that's a freehold interest of a life estate, is what it is.
Technically, it's a 3-person thing then, because right. So it's like
kind of, yeah.
Okay.
Yeah. Yeah. So, in a life estate, I could have a life estate that says, say, say my mom owned a house and she sold it, but there's a life estate in it that says I get to live there until she dies. And then once she dies, then that whoever had sold it to, then they get it. So yeah, pure ultra V.
Okay.
I bet that's very common. That's wild. I'm not familiar with that term, but I'm sure that happens a lot, right?
We don't see it a whole lot, but it does happen sometimes.
Okay.
So
that's why it's confusing to me, because what you just said is what I thought it was, but then on the book that they gave me is completely different.
Yeah.
And so it's like I'm just confused about it.
Yeah.
Okay.
Yeah, because then there's also the doctrine of merger. Here's the good news. You don't really ever have to use it. It doesn't come up in actual real estate very often. So, and if it does, that's one of those where an attorney's involved and, those things come up. But yeah, it's not very common. And I don't think it ever comes up on the test. So, I mean, it could, but I don't think it does. So,
yep. Alrighty. All right. Well, yeah. Thank you, Chris.
You're welcome. Andrew, any last parting words?
No, not at all. The questions. I'm so glad you guys are asking questions. I'm so Mario, I'm so glad you didn't leave without asking that. That just turned on a light for me, and I think it helped out other people too. So I love it. Awesome. Thanks, Christopher. Yeah. Good job.
Absolutely. And honestly, I like it sometimes when we have a small group, because sometimes when you have 10 or 15 people on, that's actually when you find that nobody talks. I'm like, please just talk. So, all right. Well, thank you, everyone.
Thank you.
Like I said,
thank you again to you both.
Our pleasure. Have a great night.
Thank you.